Even if you didn't, we can help. What do I mean by that? Basically, if you have been accused of a crime or you're a suspect in a crime and you did it, you're guilty, that doesn't mean you don't have any options. We can still help you. And I'll kind of unpack and elaborate on that during this video so that you understand that you still have options and things that you can do to make sure your life isn't completely ruined just because you made a really bad choice one night or something like that. So even if you did it, we can help. Hi, my name is Marcy Faucio with Faucio Law. We're a law firm practicing criminal defense in Oklahoma City, and this is my first time to do a Facebook Live for the law office, but here we go. Hopefully it'll be helpful to you guys. You can put comments in the comment box if you have any questions, and I will try to answer those as we go through. Let me start by telling you a story. I have a client that I was speaking to recently, and don't worry, I'm not going to tell any of his attorney-client privileged information, but I thought this was interesting. I'm talking to him about his case, and we're going through all of the different options, and I'm explaining to him different things we can do and strategies we can try, and he kind of stops me in the middle as I'm trying to explain this to him, and he looks confused, and he says, but I don't understand why we're talking about options and strategies. He's like, I did it. And it almost made me laugh. I didn't laugh, that would have been rude, but he clearly was kind of thinking about it from a different way. I think about it as an attorney. He was thinking about it from a very different perspective, and I'm sure other people think about it that way as well. And so what I explained to him at that point is the same thing I'm going to talk about in this Facebook Live, is even if you did it, we can help. That's not the end of the discussion. So there are 3 different options or strategies that I want to discuss today during this Facebook Live that apply even if you did it, meaning even if you did commit the crime you're accused of committing. So 3 different things you can do, or 3 different things that 3 different ways that we could approach your case even if you did it. The first way is what I kind of call the technicality. In other words, there's a technicality that even though a person committed a crime, they get off on a technicality. You may have heard that on the news or somewhere, that they got off on a technicality. So this one's pretty rare. It doesn't come up very often, but it's kind of the more interesting one, meaning the news is going to talk about it and things like that. So even though it doesn't happen very often, it's actually probably the one that you hear about more often because it's more newsworthy or noteworthy or more interesting, something like that. The technicality. And it's very rare, but it's also very effective. A couple of examples. You have probably heard of the statute of limitations. That basically is the period of time that the prosecution has to file charges. So if I actually had this happen in a case recently, and of course I'm not going to talk about anything specific in any of the examples I bring up for attorney-client privilege and privacy confidentiality reasons, but I can tell you this, we had a case where I knew there was a potential of a certain action being filed, a certain type of lawsuit, and so I was kind of watching it and tracking it, but I also knew that in this particular situation the statute of limitations was pretty short. It was 1 year. So I was able to kind of watch that, and as the 1 year got closer and closer and nothing had been filed, I started to get interested. And sure enough, it was about at the 1 year and I don't know, 7 or 8 days after the 1 year mark is when they filed the case. And they missed the statute of limitations. So in that particular case, we won because of a technicality, and it's because the prosecution missed the statute of limitations, missed the filing deadline. There can be technicalities like jurisdiction, meaning where a court case occurs and where it's filed. There can be technicalities based on whether or not there was a illegal search and seizure. If there are Fourth Amendment issues at play, then perhaps you can do a motion to suppress that the search was illegal and then the evidence that was found gets suppressed. So things like that, a technicality. Again, if you have any questions on this topic about getting off on a technicality, then type it in and I can talk about it in the comment section, or type it in the comment section and I'll talk about it. One question though that we've heard a lot and that I was asked before I started this is about how it works with your rights, your Miranda rights. In other words, a question we get a lot of times, what happens if they didn't read me my rights? Does that mean that the case is going to get dismissed? And that would be an example of a technicality, getting a case dismissed on a technicality, but unfortunately, it doesn't work that way for a couple of reasons. So when people say they didn't read me my rights, the cops didn't read me my rights, they're referring to Miranda rights, which comes from a case from the United States Supreme Court, Miranda. And in that case, basically what the law is, or what's required in order for the cops to read you your rights, are two things. Basically, you have to be in custody and the cops have to be interrogating you. So if you're just walking down the street confessing to crimes, then your Miranda rights don't come into play, because if you're walking down the street, you're not in custody, and if the cops aren't interrogating you, then you don't have either of those. You don't have the custody and you don't have the interrogation. So Miranda rights don't come into play. No one would be required to read you your rights. The other part of how Miranda rights comes into play, as far as whether or not you could get off on this technicality, is what happens if your Miranda rights are violated. So if you are actually in custody and the police are interrogating you without having advised you of your Miranda rights, then yes, your Miranda rights have been violated. But what happens if they've been violated? Unfortunately, it doesn't necessarily mean your case is going to get dismissed. It most likely just means that any statements that you made, or if you confessed to the crime or made any admissions of guilt, then your statement would not be able to be used against you. So there is definitely some use there, and it's something that should be explored. If you made a statement to the police that's not going to help you in court, something you don't want coming into the courtroom, and your Miranda rights were violated, then you certainly would want a motion to suppress your statement. But even though that technicality helps as far as suppressing your statement, it's not necessarily going to result in your case being dismissed. So that's how that technicality works. Another question that someone asked is, I referenced statute of limitations a minute ago, and the statute of limitations, again, is how long the prosecution or the state has to file charges. So let's say I commit a crime today, possession with intent to distribute marijuana. If I commit that crime today, how long does the state have to file charges against me? So that's the statute of limitations question, and what I was telling you earlier, how we were able to win a case because the case wasn't filed within the statute of limitations. So a question that we get a lot is, how long do they have to file the case against me? Because depending on where you're at, what county, sometimes it can take the prosecution a while, could be months, could even be years in a very rare situations. How long do they have to file a case against me? So it varies. That's the answer to almost every question. It depends. Anytime you ask a lawyer a question, that's going to be the answer. It depends. So it depends, but I can give you at least a little bit of a framework on how long they have. And I'm pulling up so I can kind of have it handy to look at here. The statute of limitations in Oklahoma is in Title 22 in Section 152. It goes through and lays out the various periods of time for different crimes. So it depends what the charge is. If there is a charge, for example, violation of a state income tax, has a 5-year statute of limitation. Violation for embezzlement of public money, bonds, or securities has a 7-year statute of limitations. So it's going to vary depending on what the charge is. There are, I'm going to say maybe 10 to 15 crimes where it's specifically laid out. There's a specific statute of limitations in place. And then it says the way the law is written in Oklahoma is, in all other cases, a prosecution must be commenced within 3 years. So a more simple way to look at it is kind of the general rule. The state has up to 3 years to file charges against you. And then there are some types of charges where you have even more time. For instance, if the charge is using a deadly weapon, they've got 7 years. And one that a lot of people have heard about, let me find it, it's actually in a different statute. One that a lot of people have heard about from TV or whatever is murder. There is no limitation of time, no statute of limitations for murder. So basically, if a person commits a murder in 1970, they can be charged with that crime 40, 50 years later. There's no statute of limitations for murder. But in general, 3 years, or depending on the charge, could be 5 or 7. Like I said, every answer is going to be, it depends, but that gives you at least a little bit of an idea. So even if you did it, we can help because we can explore and see if there is a technicality that could be used to your advantage. So that's one way that we can help you even if you did it. The second way that we can help you, even if you did it, or the second kind of avenue or approach is I want to make sure and make clear that there is a very big difference between committing a crime and there being proof that you committed the crime. Again, committing a crime is different from the fact that the state or the prosecution has evidence to prove you committed the crime. I don't know if I'm wording that very well, but hopefully you kind of follow what I'm saying. So even if you did it, that doesn't mean that they, the prosecution, the state, the government, whatever you want to call them, just because you did it, it doesn't mean that they can prove you did it. So let's say you committed, what's the charge I used earlier? Possession with intent of marijuana. Let's say you did in fact commit that crime. Well, if they don't have evidence to prove it, then we can help. It could be that charges don't even ever get filed, or they do get filed, but the case is really weak. It could be that evidence is lost. So in that example, possession with intent to distribute marijuana, say something crazy happens and the police lost their marijuana. They claim they found this marijuana in your possession, they seized it, they take it to their evidence room, and they lose it somehow. Well, then they don't have that evidence to prove. It's a pretty integral and crucial part of their case. Maybe they can't locate a witness. Maybe there's just a bunch of different things that they have to have, they meaning the state, the prosecution, in order to prove that a crime has been committed. And I won't go into a lot of detail, but basically in Oklahoma, all crimes have what are called elements. In other words, there could be 3 or 4 elements or things that the state has to prove in order for a person to be found guilty. And so on a possession with intent to distribute case, the state, the prosecution would have to prove the element of possession, the element of intent to distribute, and then the element of marijuana. There may be 1 or 2 more, but that gives you at least a general idea of the framework. So if they can't prove one of those elements, then they can't prove it. So even if you did it, we can help, because if the state doesn't have enough evidence to prove 1 or more of the elements, then they can't convict you. So in a situation like that, you might want to look very closely at the option of going to trial. So, and I say that's an option. You don't have to go to jury trial. That is always a defendant's choice if they want to go to trial and have a jury trial or not. And that'll lead me into my third point here in just a minute. But let me address a question that comes up kind of often in this regard as far as what kind of evidence that they have. So I received a question the other day from someone about a subpoena. And basically I mentioned that the evidence that the prosecution would need could be, physical evidence like marijuana, or it could be witness testimony. So if an eyewitness saw you commit a crime and that eyewitness comes and testifies in court, then that's a type of evidence, eyewitness testimony. But if the state doesn't have eyewitness testimony, or they can't locate that witness when it comes time for the case to proceed to court, then obviously that's going to be a big hole in what kind of evidence they have. So the question I got the other day was in regards to a subpoena and what it required the person to do. So basically this person said that she knew that someone was trying to send her a subpoena. It was kind of unclear, but she hadn't actually received it, and she was wondering if she had to come to court. And first of all, let me make clear that nothing I'm saying in this Facebook Live video is legal advice. Everything is going to be dependent upon, the specific circumstances and situation. It varies. So I'm not giving legal advice. By watching this video, we are not forming an attorney-client relationship, any of that stuff. I know that's kind of dumb to say, but just things you have to say to keep the Bar Association happy and make sure you're following the rules. So back to the question she had asked. She hadn't received the subpoena. What would happen if she didn't go to court? Did she have to go to court? Things like that. So how that works is basically a subpoena is a court order telling the person that they have to come to court at a certain time and place. You obviously can't be required to comply with something if you don't know about it. In other words, if the district attorney's office issued a subpoena to Marcy Fazio to be at court tomorrow, but I never was served with that subpoena, I never received it, I didn't know about it, then clearly I can't be held to comply with something I don't even know about. So because of that, the law in Oklahoma requires that you must have notice. and that's kind of a magic word, I'll elaborate on that in a minute. You must have notice in order for the state or anyone to be able to require you to comply. So using my example, if the district attorney sent me a subpoena to come to court tomorrow and I didn't know about it, in other words, the state didn't provide me notice, then I can't be faulted for not coming to court because I didn't receive the subpoena. So the state would have to prove that I had notice. And there are a couple of different ways they can do that. They can do it by having a process server actually come and hand you the subpoena. You've probably seen this on TV as well, where someone says, "Are you Marcy Fazio?" You say yes. They hand you the subpoena. You've been served. So they can have a person serve you a subpoena. They can do it by sending certified mail, because in order to get certified mail, you have to sign for it. So that would prove that you did in fact receive the mail and receive the subpoena. So if you do have notice about a subpoena, then barring some unusual circumstance, yes, you are required to go to court because it is a court order requiring you to comply. So like I said, there's a lot of nuance and distinction. It depends on the situation, but in general, if you have notice of a subpoena, again, in general, there are exceptions. If you have notice of a subpoena, then yes, you're required to appear. So another question we get from time to time that ties into how much evidence the state has and whether or not they have enough evidence is people sometimes want to know if cops are required to have body-worn camera. So body-worn camera, at least in Oklahoma, is relatively new. It was pretty uncommon until maybe the last 5 years. Now it depends on the police jurisdiction, and it's basically going to be a policy of each police department. So for instance, a particular police department might have a policy that yes, all officers are required to wear a body-worn camera when they're on duty, or it might be all patrol officers are required to wear it. Basically, the police department and agency can set up its own policies for who is required to wear the body-worn camera and when. Some agencies just don't even have enough body-worn camera, enough equipment for all of the cops to wear. So for instance, if you've got 100 cops and only 20 cameras, then clearly not all of them are going to be wearing the body-worn camera. And like I said, go back 5 years, there was very few body-worn camera equipment. Very few officers were wearing body-worn camera. So bottom line, a lot of officers in Oklahoma do have body-worn camera and wear it at this time. It is not a requirement. And let's also distinguish, even if the police agency requires it. So let's say Oklahoma City Police Department requires their officer to wear a body-worn camera. That's different than the court and the statutes and the laws do not require it. So no, there's no legal requirement. The courts do not require it, but police departments, various agencies will have their own policies and they may require it. So it's not going to, we're not always going to have body-worn camera in every case, but at least at our office, we're always going to check and see if they have it, because it could be useful to you in your case, or sometimes it's actually the opposite and it hurts you in your case. But either way, we want to know what there is so we at least know what we're working with. So that's the second way we can help, even if you did it, by testing and examining and determining whether or not the state has enough evidence to prove that you did it. Even if you did it, that doesn't mean they can prove it. So we want to always look through these things. So basically, number one, we're going to look at, are there any technicalities? Is there anything crazy that happened here that would result in us being able to get the case dismissed? If not, then we'll kind of go through, well, let's look at what evidence they have. How strong is the evidence against you, or how weak is the evidence against you, and determine if the prosecution actually has enough evidence to prove all of the elements beyond a reasonable doubt. That's the burden that they would have to meet if they went to trial. You've probably heard that on TV as well, but the burden of proof is beyond a reasonable doubt. So let's say there are no technicalities and the prosecution has strong evidence that you did it. Well, crap. We still have a third option that we can consider, and that's what we'll talk about now. And that is basically, even if they caught you red-handed, even if no technicalities, the evidence is super strong, then another option that we would look at and how we could help you even if you did it is mitigation and negotiation. And what I mean by that, actually 98, maybe 99% of all cases are resolved by plea bargaining. In other words, very few cases actually go to trial. Very few cases are very few cases are resolved based on getting dismissed on a technicality. Very few cases are resolved by going to jury trial. The vast majority, like I said, 98, 99%, are resolved by a plea bargain. But you don't want to obviously just go in and take any plea bargain. You want your attorney to go in and represent you and talk about the strengths and weakness of the evidence and all the various components thereof, so that you can negotiate, or your attorney can negotiate on your behalf, the best outcome possible. And that kind of ties in with one of the case. Another question that we get really often is, I know I don't want a trial, so what's going to happen? If I don't want to have a trial, what's going to happen? And that's where this, again, comes into play: negotiation and mitigation. So with negotiation, that is when your attorney's going in and meeting with the district attorney and the prosecutor and trying to comment on or address various components in your case and work out the best possible plea agreement for you. Like I said, you don't want to just take any plea agreement. You want your attorney to negotiate on your behalf. Mitigation is basically things that you can do to try and mitigate or make it better. So let's say, for example, I was charged with stealing $1,000 from my grandma. Then a way that I can make it better to mitigate would be to have $1,000 to give back to my grandma. It's a restitution. So I'm trying to mitigate and make it better. So if I mitigate and then you have an attorney negotiate for you to try and get the outcome that's as good as you can, then that's another way that we can help, even if you did it. So if you don't want a trial, which most people don't, what's going to happen? That's where we're coming into this option: negotiation and mitigation. And there's definitely an art to it. There's a lot of psychology, a lot that goes into it. And a lot of times, not always, but a lot of times we can actually get the person the outcome they want even without fighting the case or having a technicality or going to trial. Even if they have strong evidence, we can still get the outcome that you want. So at our office here, what we do, one of the first things we ask a person, a client, is basically, what is your goal? What's important to you? What is the outcome that you want? Because of course, different people have different things that are important to them. So one client might say the most important thing is not to go to jail. Another client might say the most important thing is they don't want this on their record. So once we talk to you about your goals and your outcome and what's important to you, then we're going to try and structure a way to get that outcome, even if you did it. So I gotta say it one more time: even if you did it, we can help. And that's what I'm talking about. So once we know your goal and the outcome that you want. Now sometimes it's impossible, of course. If you robbed 10 banks and you're Bonnie and Clyde, then we're not going to be able to keep this off your record and you're not going to be able to stay out of jail. But maybe we could at least minimize the amount of time that you did in jail or something like that. So it's not always possible to get, of course, the outcome that you want. But a lot of times we can do that, even just from a negotiation and mitigation strategy. So I'd say, like I said, that's one of the most common questions we get in that capacity. If I don't want a trial, what happens? And since most people don't want a trial, there's a whole other video we can do about that. But for purposes of this video, we'll just say most of my clients don't want a trial. That's not what they think is in their best interest. And so we go with this negotiation strategy. And as I said, the vast majority of cases are resolved that way. So if the most important thing to you is to not have the case on your record, then basically our strategy and our options would be aimed at accomplishing that. So we would explore different ways that we could keep it off your record or get it off your record as quickly as possible. You know, I'd walk you through the pros and cons of those options. You would tell me which one you wanted to do, and I would work it out with the district attorney if we were doing a negotiation approach, and get it off your record as soon as possible with an expungement. Expungement's a whole other topic as well. You can get more information on that by calling the office or on our website. You can get more information on all this stuff by calling us or going to the website, sending us an email, whatever is more convenient, and we will definitely try to help you out with there. So hopefully this video has been helpful to you, or if you know someone that it would be helpful to, feel free to obviously share this video, like our page. And if you have any questions or need help, or you want to know how we can help you even if you did it, then give us a call or shoot us an email and we'd be happy to help. Thanks.